Welcome to the NREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, everybody. Welcome to the show. Today, our topic is short-term rental laws, how to protect your vacation rental rights. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, give us a like. Subscribe to our channel. We are on Facebook and YouTube. Even if you're not new to the show, make sure you go and do that. We'd be happy to have you following us. With that, Sean, what is our legal update today?
So today I want to talk about agreements for sale. What are they and when you should use them? So an agreement for sale, also referred to as a contract for deed, is basically an agreement that you enter into for purposes are similar to a seller carryback financing transaction, where you basically say, I'm going to buy this property from you, but I'm going to do so over time. And so you enter into this agreement, and it has, different payment terms associated with it. But title to the property doesn't transfer. So the warranty deed is generally executed and held in escrow, normally by a neutral third-party company called a servicer or servicing agent, who collects the payments under the agreement for sale and then distributes them to the party that's selling the property or the record title holder. And they hold that warranty deed. And then if the party buying the property fully performs, then they take that warranty deed and they record the warranty deed. Now, a couple of things to keep in mind about an agreement for sale is, number one, it does transfer possession of the property. So it provides that the party buying it has the right to possess the property, the right to use the property, the right to improve the property, the right to basically treat the property as though they are the actual owner, despite the fact that they are not the fee title holder, the record owner of the property. And then the second thing about an agreement for sale is your ownership interest can be documented, or not your equitable ownership interest can be documented through the recording of, say, a memorandum, right? So there's a document that is then recorded stating that, oh, I've entered into an agreement for sale, and, I have the right to, basically utilize the property as though I'm the owner, even though title hasn't transferred on the property itself. The difference between an agreement for sale or a contract for deed and, say, a typical seller carryback, where you have a promissory note and deed of trust, or a promissory note and mortgage, is that an agreement for sale provides for a forfeiture as opposed to a foreclosure. So the timeframes that you are required to meet after you give notice of a breach or a default are a little different than, say, our typical foreclosure here, which is basically a 90-day time period for somebody to bring the loan current before a sale of the property. Here, there is no sale because title is never transferred out of the seller's name. It's still with the seller. And so what you do is you record basically a notice of breach and notice of forfeiture. And then, depending on how much has been paid by the purchaser or the buyer, that determines the amount of time that you have to wait. So, a forfeiture can be as short as 30 days, could be, upwards of, 6 months, I believe, by statute, where you have to wait before you can actually then, take title to the property or forfeit the buyer's interest in the property. So when do you use an agreement for sale as opposed to the note or deed of trust? One would be if you have a lender that you're going to take the property subject to. Let's say they have a deed of trust out there, or a mortgage, and that deed of trust provides that the actual, transfer of the warranty deed is the, alienation or would invoke the due on sale, but maybe the agreement for sale, when title doesn't transfer, maybe that, is sufficient. And it really depends on the terms of the deed of trust and the mortgage. A lot of times, those documents are going to prohibit a deed of, or an agreement for sale as well. That's going to be considered a transfer. But the second time that you might want to use it is, it's not as complicated of a document as say, having a promissory note and deed of trust or promissory note of mortgage. It's just one document that you execute. And so you may want to, save, time and money and just do that one document versus doing a promissory note and a deed of trust. And maybe even, you can avoid a purchase contract if all you're doing is an agreement for sale. So there are times that you're going to want to, use that document over your typical, creative financing subject to type transaction. So it's an alternative, and it's available, here in Arizona and in other states as well outside of Arizona.
Sure. All right. Thank you for that, Sean. Update for our listeners. We mentioned this last week, but another reminder that in REM, the podcast, we will be live on site and we'll be streaming live from the Buy and Hold meetup on September 27th. And that's starting at 4:00 p.m. So a couple things for those that might be interested. Sean, who can come to the the Buy and Hold meetup?
So it's open to anybody. It's a free event. There's different ways to RSVP. So on our INREM Facebook page, we're going to have an opportunity to RSVP through there. Their Buy and Hold has its own page, so you can RSVP through there. But basically, it's designed for anybody who's interested in real estate, whether that's a real estate licensee, whether that is an investor, a lender, a title representative, an attorney. So I attend these on a regular basis, and there's a couple of other attorneys that are regularly there and attend as well. But basically, anybody that's interested in real estate can attend. They have free like appetizers and drinks and things like that. So it's a fun event, and there's a lot of networking that takes place, a lot of real estate investors that are there, and then a lot of good content and information that's provided.
Yeah, so I know that it is a fantastic opportunity to go meet investors, lenders. In fact, on our last podcast, we spoke to a lender who's a regular attender who spoke about the importance of getting out, meeting people in the community to find good contacts. But obviously, it's a great place for marketing. But I know, as you mentioned, there's good content as well, and you're speaking this month. So tell us about the topic.
Yeah, so my topic is going to be creative financing subject to transactions and wraps. And so we're going to basically go over the ins and outs of the documents that are needed to effectuate different creative financing transactions. And so that's what's going to be creative financing, and subject to it will be the topic.
So why don't you explain for our listener what it is that we're going to be doing as an INREM podcast?
So what we're going to be doing at the event is we're going to basically be live streaming the event. And so the event starts at 4:00, and it has open networking from 4 to 5, 5:15, right in there. And then they have speakers and the topic, and it's a more formatted at that point. But from 4 to 5, we're going to be there, and basically we're going to be doing our show live. So we will interview the hosts of the event, interview some real estate investors that are there, and then we're going to open up, the last 15 to 30 minutes to allow anyone to, if they want us to discuss a particular legal topic, they can say, hey, why don't you discuss this topic? And We'll discuss it, provide legal information and education to them during the last 15 to 30 minutes before the actual formal presentation starts.
Awesome. Well, make sure that you are there at the Buy and Hold meetup September 27th. It'll be a good time. Look forward to seeing you there. And if you can't make it, the whole thing's going to be live streamed so you can watch it. So we appreciate your involvement. With that, let's get into our topic today. Today, we're talking about short-term, or otherwise known as vacation rentals, the law that applies to those short-term vacation rentals. And with us today to talk about that, we have Arizona attorney Chris Charles. Chris, thanks so much for being with us.
Pleasure to be here. Thank you for having me.
Chris is the managing partner of Provident Law located in Scottsdale, Arizona. Chris, tell our listeners about Provident Law.
Provident Law is a full-service law firm to our business and real estate clients. So we offer legal advice and representation regarding short-term rentals, anything real estate, commercial or residential. We have attorneys that practice in collateral areas that touch up against real estate, corporate law, probate, bankruptcy, and my focus is specifically on real estate.
Now, I know Provident, like you just said, is somewhat broad in what it is able to do. You do a lot of real estate work. How did you get into real estate law, and then specifically into this kind of niche category of short-term rentals?
Sure. Well, after a lot of sleepless nights practicing criminal defense my first year of practice, I thought I should do something maybe a little more boring and less emotional and stressful than criminal law, and had an opportunity to go work for a real estate boutique firm here in town representing the Arizona Department of Real Estate. I'm sorry, the Arizona Association of Realtors as a hotline attorney. So found out that I really enjoyed doing that type of work, representing agents, brokers, investors, and really developed a kind of a niche practice just focusing on real estate. And then back when the Super Bowl came here last, which was I think 8 years ago, sounds about right. Short term, a lot of my clients started having getting into the short term rental business. So I started specializing, focusing on short term rental legal advice and teaching seminars. So I've taught seminars for the Arizona School of Real Estate and Business and the State Bar on this topic for about 8 years now.
Now, side note, the Super Bowl is going to be here in February.
It is,
You're
yeah.
coming again. Are you already getting calls? You already have clients preparing for this?
Certainly. Even so, we're in the fall now, but yeah, I would say starting the beginning of this year, back in January, I had clients already gearing up for Super Bowl, clients trying to buy properties specifically for Super Bowl. But yeah, it's already had a pretty pronounced impact on Arizona real estate. Like I said, starting back about a year ago, probably.
So with a lot of our guests, we like to start kind of from the beginning, from the perspective of the investor, somebody who's, whether they're just getting into real estate investing or maybe into this, getting into specifically vacation or short-term rentals. They like the economics of it. They think it's going to fit their business model, and they've come to you and they want legal advice about how to best structure this. How do you generally recommend as a best practice for a business structure, or how to structure a business that's really focused on short-term rentals?
For the corporate model, I think the best approach is to have at least 2 different entities for the short-term rental operation. So the investor wants to have one entity to hold title to the property. Let's say, for example, the Silverleaf LLC or the Elm Street, LLC. So that will be the property, the company that owns title to the property. And then you want to have a separate entity for the management of the operation itself. And so the management company will be the entity that is actually contracting with the renters. You don't want to have the owner contracting directly with the renters. It's good to have this third-party management company that handles that. Or, of course, if the investor is hiring a professional property manager to do the management, then the investor ought to require the property manager to be the one that's actually contracting with the renters. The idea being that we just have that extra layer of protection. When we start getting into an actual portfolio, owning multiple different properties, then it's probably prudent at that point or at some point to have like a holding company that will own the various entities. And I think that helps with bookkeeping, tax records, and that type of thing.
Beyond formation, I want to actually ask you a contract question. And I know there's endless formation types of contracts, operating agreements, bylaws, depending on the type of the corporation. But I really want to ask you from the perspective of the short-term rental investor. And let's start with contracts. What would you identify as some of the must-have contracts they need to be thinking about having right from day one?
Well, certainly from day one, we need to have a thoughtful, custom short-term rental agreement, utilizing the terms and conditions from VRBO, Airbnb is not ideal. So we want to have an agreement in place that protects you, the investor. So a thoughtful short-term rental agreement that we can also upload onto these platforms, these electronic third-party platforms like VRBO, to require the guests to read and approve before making the booking. The short-term rental contract itself needs to be very, very specific and clear that the contract, the relationship is governed by Arizona's innkeeper statutes, not the Arizona Residential Landlord Tenant Act, which is drafted and aimed at protecting families for long-term lease scenarios. So it's a little bit more pro-tenant friendly, but this is essentially a commercial transaction, kind of like a hotel. And the innkeeper statutes are very, very brief and give great deference to the parties as to what terms to include. So there's a couple things specifically that you really need to have in there. Number one, the Landlord Tenant Act doesn't apply. Number two, you want to have a cancellation policy, a really thoughtful cancellation policy when the fee, in other words, when the fee is earned and whether it is refundable, and if so, under what limited circumstances. Number three, I think it's also important to have a express provision giving the owner or the manager the right to perform a non-judicial lockout in the event that there's a party or any violation of the rental agreement.
I want to jump back for a moment. You addressed the need to have some sort of short-term rental agreement beyond what Airbnb or VRBO provides. In what ways do you find that they're typically deficient? I can see why most folks like to defer to stuff like that because it costs them less money with lawyers to do their own customized contracts. But what ways do you find that they're mainly deficient?
Well, that's I think the three things that I just said. I don't think any of those are covered under their custom terms and conditions. In addition, you want to make clear one of the things that I include, and I just had this legal issue come up in our office last week. One of the things that I made clear in our agreement is that any adult who's occupying the property is agreeing to be bound by the terms and conditions. So I had a situation, it was a very expensive luxury property where they ended up owing my client tens of thousands of dollars, and the actual quote unquote renter was just this shell entity that didn't have any assets. But because we had this agreement in place, the principals of the company were legally on the hook and had to pay the money, which ended up being like 25 grand. So that's, I guess that's another example.
Now, you mentioned another thing I wanted to pick up on, what I thought was interesting. So expressly stating within the short-term rental contract that the Arizona Landlord Tenant Act does not apply. I think that was one of what you indicated, that it does not apply. And if there were any confusion here, this law does not apply to what we're talking about. But you also mentioned carving out the ability to do a lockout. Did I hear you correctly?
Right. Yeah. If the Landlord Tenant Act applies, then, and if we have a bad renter, the only way to get them out is to do an eviction action. Call up Andy or Sean and do a judicial eviction action, which is pretty efficient, at least as far as legal actions go, but way too long if you're the owner that wants to get your property back. You want to get back immediate possession, not have to wait a week or two. But if you have a contractual provision that gives the owner the right to do a non-judicial lockout, you don't have to go to court. You can go and take back possession just like a hotel would if you had a guest that didn't pay their bill or broke the terms and conditions of the rental contract.
Hey, Chris, so you mentioned disclaiming the Arizona Residential Landlord Tenant Act. How important is it to limiting the time frame of your rentals in order to enforce that provision? Meaning, I can't go and enter into a 6-month lease for my house and say, oh, the Arizona Residential Landlord Tenant Act doesn't apply, right? Because the court's going to say, no, it applies. And I don't care what your agreement says, it applies. So are there any time restrictions that would basically void or time, rental periods that you have to maintain in order to avoid voiding that provision in the agreement?
Right. Actually, right in one of the first sections of the Arizona Residential Landlord Tenant Act, the statute expressly provides that the landlord cannot require the tenant to waive any of the provisions of this act. And if there are any provisions that contradict the act, they're void. So it needs to, the rental agreement needs to be drafted in such a fashion that it doesn't fit the parameters, the four corners of the Landlord Tenant Act. And so the Landlord Tenant Act, one of the exceptions to it is that it does not apply to recreational lodging, transient lodging, recreational lodging. And then we have elsewhere in the Arizona Revised Statutes a definition of transient lodging, which is a tenancy week to week, daily or week to week, or any period 30 days or less. So it's really important that I guess that's one of the other reasons that you really need. It's very important to have a written short-term rental agreement that states that the duration of this term shall not exceed 30 days. And obviously you want to put what the term is, but I think a provision in the contract that makes it really, really clear that the term shall not exceed 30 days. And then I also want to include a provision that the renter is not to receive mail, that the renter expressly represents and warrants that this is not their primary residence, that they have another residence somewhere else. Try to include a couple of different facts so that there's no shadow of a doubt, no question that the Landlord Tenant Act does not apply.
So, Chris, let's talk about the laws that do apply to short-term and vacation rentals. There are such laws. Some of those are relatively, with the growth of short-term rentals, especially in a state like Arizona over the past 10 years. You even mentioned it. Maybe the Super Bowls would kick this all off. I don't remember this being a big thing until then, but now it's a thing, especially with VRBO and Airbnb. But tell us a little bit. We do have some laws in place that cover vacation rentals specifically. Tell us about those laws, and initially, what properties are covered by short-term rental laws, and what are not.
Right. So one of the things that really opened the door here in Arizona for the short-term rental industry, in addition to Airbnb, VRBO, was Governor Ducey signing into law SB 1350, which was about 6 or 7 years ago. And that law made it clear that no city, state, county, no city, municipality, state, county can enact any legislation to restrict short-term rentals. So the state made it really clear we are welcoming short-term rentals in Arizona, and none of the governments can take any action to restrict them.
Now, was that in response of the response at all to municipalities attempting to restrict short-term rentals?
There at that point, I think Scottsdale had been restricting short-term rentals, and then there were a number of other cities, Tempe, Sedona, others that were like in the process of passing legislation to restrict short-term rentals. And so Ducey and the legislature just took a proactive approach, making it clear that in Arizona we were going to welcome that sharing economy here. So that statute's been amended a couple of times since then, because the state, along with my office and my clients, wants to do what we can to prohibit party houses. And so that's kind of been the tension ever since 1350 was enacted, was now, okay, we're welcoming short-term rentals. Now what can we do to lawfully regulate them to try and keep out the bad actors?
Is there, does this apply to any type of property or just a particular type of residential property?
Yes, SB 1350 applies to residential properties, so single-family homes, condominiums, duplexes. Does not apply to commercial properties.
What about the use? We know, as a general rule, when we talk about a vacation rental, we're talking about staying in a place for a weekend or a week or something like that. But well, let's talk about two things: time limitation and use. What does the investor have to stay within to stay outside of those, one, the four corners of the Landlord Tenant Act, and fall within this legislation?
So it's intended to promote short-term stays, for 30 days or less, not events, parties, bar mitzvahs, that type of thing. So the law protects short-term stays, but it does not protect any use other than that. So any use for like an event, a wedding, or something like that, the law does make clear that it is not giving the owners, the operators, the right to go and use the property in that fashion, unless, of course, they have the appropriate temporary use permit from the local jurisdiction.
What about registration and licensing requirements? You've got the investors coming to your office. You've just planned out their entire structure and formation. Do they have to register? Do they need a license?
Yeah, that was one of the amendments that happened a couple of years ago at ARS section 42-5042. Now the owners of a short-term rental property do have to apply and obtain a transaction privilege tax license, and they need to list that license number on all advertisements. And actually, this was a kind of a cool lesson for anybody that's looking to be a lobbyist, or if you're ever wanting to try and change the law or pass a new law. Find a way to generate revenue for the state. So find a way to generate some taxes for the state, and that's a good way to kind of slip the law through. So so the opponents of short-term rentals had been trying for a few years to either repeal SB 1350 or to amend it to impose greater restrictions, and the way they got it through was this requirement here that Andy just asked about. So the owners do have to apply for and obtain this transaction privilege tax license, and then post that everywhere. And the reason for that is so that the state can make sure that they're getting all of their transient lodging tax, which is a much higher tax percent than any regular rental tax.
I can imagine that this requirement is often missed by investors. Is there a penalty associated with the failure to obtain it?
There are penalties. Yeah, the penalties are set forth in the statute 42-5042. I don't recall what they are off the top of my head, but there are indeed penalties. Airbnb, VRBO, most investors that use those type of platforms will elect to have them collect the tax. So that there is kind of a built-in process for that if you're doing it online.
Gotcha. All right. So in talking about the law and the state law that limits municipalities from restricting the way that they word vacation rentals, that isn't the only thing that investors have to deal with, whether it's short-term rentals or other types of investments. We've got this thing out here in Arizona that everybody either loves or hates, and it's the homeowners associations. So in what way, or let's start with this, did the legislation that we're talking about impact, or what impact does that initially have on HOAs? Are they bound to follow that legislation?
Really none. So I would say that the SB 1350 and the related laws have really no impact on private HOAs. So all that the law says is that the state cannot restrict short-term rentals, but that local communities, planned communities, HOAs, can further restrict property use as long as it's not illegal. So again, SB 1350 is just telling the cities, counties, municipalities what they can and can't do, but leaves open the question of whether the HOAs want to further regulate that. And so one of the biggest battles that most of my clients have had the last 8 years has been with HOAs. Probably that's where I get involved more than anything with short-term rental properties, is with HOA issues. So I think it's a prudent business approach before you acquire a short-term rental property to carefully assess the community. Where is it? What's the community's temperature as to short-term rentals? Because sometimes even if you can do something, even if it is legal, you still need to ask yourself, should I do it? So maybe it's legal, but if all the neighbors on the street, come at us with pitchforks and are picketing with signs and stuff all the time, is that really the neighborhood that I want to be at? So anyway, HOA restrictions have been a huge issue for the past 8 years since 1350 was passed, 6 years. However, we did receive a ruling just I guess a couple months ago that really turned this law on its head in regard to HOA law and what they can and can't do in restricting short-term rentals, because prior to this ruling that just came out by the Supreme Court, unanimous decision by the Arizona Supreme Court, the Callaway case, prior to the decision, we had HOAs just amending their CC&Rs to restrict short-term rentals. So pursuant to SB 1350, the state, the city, the county cannot restrict short-term rentals. What that means is they are lawful. It is a lawful use of your property unless the CC&Rs, unless the HOA has CC&Rs in place that prohibit short-term rentals. And probably 95%, I've looked at this point, thousands of CC&Rs in my career. And out of my review of all those CC&Rs, probably about 95% of them say nothing about short-term rentals. So it's probably 5%, probably less than 5% of the CC&Rs in Arizona have had drafters that were thoughtful enough to carve out an express prohibition against transient lodging, hotel use, short-term rental use. It's really fascinating. I mean, I've seen some going back to the 70s that have it, some in the early 2000s. I think now that's kind of a general term for drafting, but wasn't very common until recently. So most of the communities here in our state, it was lawful use to do short-term rentals. So what we had in response to SB 1350 is we had the HOA boards scrambling in many communities across the state to amend their CC&Rs to now include an express prohibition against short-term rentals. But the game changer now, and that created a lot of uncertainty for investors, right? Because I would tell my clients, I would say, do your due diligence. There's a lot of homes in the valley or in Sedona, wherever you want to go. There's a lot of homes. So do your due diligence, but before you put an offer in on a place, send me the CC&Rs, or tell me the community. I'll check it out and let me advise you as to whether or not this is a lawful use. So I would review CC&Rs and say, okay, yep, just as I thought. It's a lawful use. There's no express prohibition. So the investor then goes and buys the property, spends hundreds of thousands of dollars improving it, furnishing it, and then the association would go and amend the CC&Rs. I had this happen quite a few times. So that's a real kick in the pants for the investor. But what the Supreme Court of our state has now said is, in the Callaway decision, is unless the amendment was reasonably foreseeable, then the amendment is not going to be valid. So the way I explain the Callaway decision is HOAs are authorized to amend existing provisions in the original CC&Rs, so they can tweak any existing restrictions that were in the original CC&Rs, but the HOA cannot add entirely new provisions. Okay, so it needs to be reasonably foreseeable, and so that just complies with our due process notions that we take to heart. We take that seriously.
Chris, I want to talk to you about some of the things maybe you've seen with these HOAs in trying to prohibit the short-term rentals within their community. And I've seen this with rentals in general, where the board has gone and so not the members, right? The board, the elected, 5 or 6 people within the community that have been elected to sit on the board that, make certain decisions and things like that. And they pass rules and regulations, making it difficult for landlords. Have you seen those boards try to pass rules and regulations that would put time limits or time restrictions on rentals within their communities?
Many times, and that's the easiest thing in the world for us attorneys to deal with. So when my clients, tell me that their board just unilaterally passed these new rules and regulations restricting short-term rentals, I just kick out a cease and desist letter to the board, and literally 100% of the time they back down. Multiple times I've even gotten an apology. so that's not hard to deal with. But yeah, that's an entirely unlawful action by the board to take that type of substantive decision in a community on a property right.
Right. And that's an important principle for real estate investors in general, that own properties within HOAs, that, while the board has the ability to manage and run the association, they do not have the ability to put restrictions in place on the use of property. That's where
the board does not have the right to amend property rights. Yeah.
Right, exactly. And that's where the amending of the CC&Rs, if the declaration doesn't have the restriction, the board can't add it, on their own. They have to go through the process of obtaining the right percentage of association membership to amend the CC&Rs, right?
Well, now it's even more than that. So that was true 6 months ago. So 6 months ago, if the board wanted to amend the CC&Rs, they had to do a ballot and circulate an amendment, and then acquire the requisite number of votes, which is either a majority or a supermajority, depending on what the CC&Rs said. So that was the process, forever ago, until just recently when the Callaway decision was passed. Now Callaway says is unless this amendment was reasonably foreseeable, they cannot do that, even if they get a majority of the votes or supermajority. So now what that means is they would need to get 100% votes, which there's no chance of that happening. There's zero chance of that happening, because there's always going to be at least one investor in there that's opposing that. So yeah, it really is a huge game changer for investors now, and gives them a lot more, a lot less risk, a lot more predictability on their investments. And so what I do recommend, though, is that before an investor acquires a property, closes on the purchase of a property, to have a real estate attorney take a look at the CC&Rs, so that the attorney can advise on what the chances of success might be if the board were to try to amend those CC&Rs to impose a short-term rental restriction. And basically, this is what I say. This is what I look for. I'll do a scan to see if there's any mention of rental or lease in the document at all. If there's no, and many times there's no mention. So I would say well over half of the time, higher than that, the CC&R is just totally silent when it comes to rental. So if that's the case, it cannot be amended to restrict short-term rentals, because that is not going to be foreseeable. If there was zero restrictions on rental to begin with, there's no way it's foreseeable for this brand new restriction on short-term rentals to be in there. On the other hand, if there is some provisions on renting properties, then it may be foreseeable. And so that's, you really need to have an attorney take a look at that and give you advice.
So I would agree with you that the Callaway case does kind of put the screws to HOAs and their ability to amend the CC&Rs when it comes to short-term rentals, especially where, like you said, the CC&Rs have no rental restrictions whatsoever. But I do want to play devil's advocate just a minute here. So the Callaway case did not involve any type of rental restrictions. And my concern is in dealing with these HOAs and their attorneys, they're quite unreasonable most of the time. And so my concern is that the HOA and their attorneys are going to say, no, Callaway, that dealt with, a 5 lot community and a rural community dealing with livestock and other things like that. It had nothing to do with rental restrictions. And, we had granted Callaway would trump this case, but an unpublished decision from our Court of Appeals that, specifically addressed this very issue that, right at the time the Arizona Supreme Court was deciding, Callaway, they declined review of this case. What would kind of be your comeback to say, well, no, just because Callaway did not deal with these short-term rental restrictions that, it still has the right, holding and language for us to be able to, say, no, unless there's time restrictions within the document itself, you guys are out. And have you seen that successful? Have you seen HOAs back down so far since, the passing of Callaway?
I haven't. No, I would not say generally I've seen HOAs back down. I think they've pivoted their strategies for how they're handling amendments and those type of things. But I haven't seen them willingly back down. And our firm has had to initiate and respond to several lawsuits just since Callaway, just in the last couple months. So these cases are working their way through the trial courts as we speak. But I do feel really good about the holding of Callaway, and the fact that it's a unanimous Supreme Court decision that no doubt happened while this hot button issue with short-term rentals is percolating up through the courts. So the justices, I think, knew what they were doing and knew the reach of this holding. But the holding itself, is pretty clear that the HOA cannot amend restrictions where the property owners could not reasonably expect from the language of the original declarations. So there's this whole reasonable, foreseeable, issue analysis. And so that's why I say, I think a really safe way to play it is if there's no mention at all of rentals or leasing, that's just not going to be a foreseeable restriction. And I wouldn't put it quite the way you put it, Sean, putting the screws to the HOAs. I think it's really the Supreme Court standing up for property rights, standing up for due process and property rights, because as I think Andy said, there's kind of a love-hate relationship. There's definitely strong feelings toward HOAs here in our state. I remember as a kid growing up, one of the neighborhoods where a lot of my friends lived at, we used to love playing basketball in the front driveway. And my friend got in trouble by the HOA because, they didn't want him to have a basketball hoop in the front yard. And we thought that was like communist Russia. So it's just in Arizona specifically, I think out of all states, we take our property rights seriously, and it's a very sensitive issue with people telling us how we can and can't use our property. And so I think our Supreme Court's just saying like, hey, look, if a property owner buys property subject to existing CC&Rs, they have fair notice. They could have bought in some other community that doesn't have those set of rules, but they have advanced warning that if you come into this neighborhood, these are the rules that you need to live by. It's entirely different than for the HOA to go and just, pass entirely different rules that they didn't have a chance to review and agree to before they went in there. And so I think that's all that Callaway is saying is, in order for an amendment to be valid, enforceable, lawful, there needs to have been reasonable notice of that potential amendment.
Yeah, I agree with you. I'm just concerned that attorneys like us that represent real estate investors and love to see these types of decisions come down that, free up property rights and prohibit, unreasonable and unforeseeable restrictions on those rights. I'm just concerned that these HOAs, they're not viewing it that simply. They're
of course,
they're going to fight till the bitter end.
They're going to try and view it very narrowly,
right?
Based on the facts and those limited
Right.
circumstances. I think they're going to lose credibility if they do.
I hope so. I live in an HOA and everyone hates their HOA until your neighbor's obnoxious and you need to do something about it, but
I was just going to tell a quick story. When I was in undergrad, I was living with my brother in an old historic neighborhood in Phoenix, and it's a beautiful neighborhood. It's a really cute neighborhood with big lots and older homes. And in 30 days, in 1 month period, the neighbor just to his left painted his house canary yellow, like a bright canary yellow, and then less than a month later, the neighbor two houses down painted it candy striped red and white, like a barber type thing. And it was just bizarre. But then I just realized like, oh, okay, that's one of the benefits of having an HOA is that we try to have a common scheme and have the properties look a certain way. And so they definitely add value.
So Chris, do you think the HOA strategy now goes to focus on the boundaries of foreseeability, essentially, to see how far we can bootstrap whatever provision into being something that is foreseeable that would allow us to make this amendment? I mean, that seems to be the little bit of wiggle room there is to kind of test that.
Well, I mean, our firm represents a handful of HOAs and some really large HOAs even, and so we just advise our clients on a case-by-case basis based on their original set of declarations, conservatively what we think they can or can't do, and just let them know the risks. I guess one of the things that HOAs know is that if it's questionable whether they can do it, it requires somebody to sue them to hold their feet to the fire on that. And I think some associations just take the chance that they're not going to get called on it. Sure.
Now, very recently, Arizona and Governor Ducey has signed new legislation, SB 1168. Why don't you tell our listeners a little bit about that and what it means for short-term rentals?
Right. Yeah. Just recently, Ducey signed SB 1168, again, trying to strike this balance between authorizing short-term rentals and also regulating party houses and trying to be good neighbors. So 1168 is referred to as the three-strike rule that now imposes. Actually, it's kind of an interesting law because it doesn't actually create any fines or impose any requirements in and of itself. All 1168 does is it authorizes the cities to go and enact their own ordinances consistent with 1168. So I just met with a client earlier today that has a property in Fountain Hills that is immediately adjacent to a party house. They've had in less than 12 months the party next door has had 150 parties.
Oh,
That's like one every 2 days. So 150 parties. So this bill definitely is aimed at this property in Fountain Hills. The bummer for him is that this law doesn't give him any teeth. It doesn't give the state any teeth. It doesn't give Fountain Hills any teeth yet. So what this means is Fountain Hills still needs to go and pass their own ordinance that will now be consistent with this. So what 1168 is basically suggesting is that the states impose ordinances that have a 3 strikes rule that sets a fine of either $500 or 1 night's rent. So if it's a short-term rental property, if they're renting it for $1,000 a night, then the first violation would be $1,000 a night or $500, whatever is more. For a second violation, it doubles that. And then for a third violation, it goes to either $3,500 or 3 nights rent. So there's some pretty steep fines there. But what I think is really important is that this new law now authorizes the cities to suspend the licensing of the short-term rental operators. So the short-term rental operators are required to obtain a permit now under this new law. And there's going to be so many of those that they'll hand out. So the short-term rental operators will have to apply for and obtain a operation permit, and then that permit can be suspended if the operator gets 3 or more violations in 12 months' time. There's a third requirement. Oh yeah, the third requirement is that they have to have a local contact, like not somebody in Canada or California. There needs to be local boots on the ground here that can respond to complaints.
Chris, is there a time limit for responding to those complaints? Because I know there are some municipalities, I think, impose like ridiculous time limits, like an hour or 2 hours, you know, if you have a complaint.
Paradise Valley specifically, yeah.
Yeah. And
this new law doesn't address the time limits on that.
But it probably frees up or confirms that municipalities can establish time limits for a local response to, you know, noise complaints and violations like along those lines.
For issues affecting health and safety,
yeah,
you know,
okay.
the municipalities can impose additional requirements. Yeah. The other thing the law does is it does require the property manager to carry general liability insurance with a policy limit of at least $500,000. Yeah.
So what is Paradise Valley's requirement? Is it 2 hours? Do you know?
I don't recall off the top of my head, but I don't think it's valid anyway.
Oh, you don't?
No, I don't. Yeah, I don't think it's enforceable. I don't think it's going to hold up in court.
Does it violate the original state law that prohibits the municipalities from, you know, imposing?
I think it oversteps.
Okay.
Yeah.
Are the penalties that may be coming? I mean, what this is encouraging is an onslaught of new enforcement mechanisms through each municipality to kind of enforce this. Does this necessitate, in your estimation, kind of a rethinking of landlord rights under the short-term rental agreement to be able to come in? Or maybe your short-term rental agreement already addresses the ability to essentially, on notice from whatever municipality, that whatever is going on violates whatever code, and you've got such and such time to fix this. Do you think this is going to necessitate some rethinking of, or the addition of contract provisions, given the landlord or property manager the ability to kind of an emergency get back on there and comply?
Yeah. So two things. The short-term rental agreement needs to make clear that needs to have an express provision that the renter agrees to comply with all laws, CC&R ordinances, and a violation
that's already there.
That's already there. And a violation of any of those is grounds for immediate termination of the rental agreement. Also, the agreement needs to make clear that the guest agrees to indemnify and hold harmless the owner concerning any violations. Because I have dealt with that in PV specifically, where the owner gets some pretty hefty fines for unruly gathering. That's kind of one of the big ones, the unruly gathering ordinance in PV that has significant fines and violations that comes with that. So we need to make sure that the renter is on the hook for that.
Chris, so before we came on today, we were talking about management agreements, and you brought up a good point. I definitely want our listeners to hear this because it's very important to have a provision along these lines in there. But talk to us about the management agreement provision dealing with who owns the data from guests.
Right. So this is a very, I found out it's kind of a lucrative area. The data management, data, the name's not coming to me, but just like the data industry associated with short-term rentals is pretty lucrative, and it's definitely very meaningful to the short-term rental investor, the operator. And what I mean by that is the actual rents that are being charged and the actual rents that are being received. And there's a tension between the property man. There can be, and oftentimes is a tension between the property manager and the investor as to who owns that data. And many property management agreements prepared by the property manager have provisions that make it clear that that's confidential information and that confidential data belongs to the property manager. And it might not seem like a big deal to the investor going into this that hasn't thought through a few moves ahead. But most investors have the plan, or should have the plan, that at some point after they've leased up the property for a year or two, to then sell it as an income producing property. But in order to successfully market the property as an income producing property, you need to have that data so you can show the potential buyers what the rent rolls look like. And so that needs to be really clear in the property management agreement to protect the investor.
All right. Thank you, Chris, so much for coming on the program. We appreciate it. Where can our listeners find you?
Oh, thanks. Yeah, gentlemen, thank you for having me. It's a pleasure always. Our website is www.providentlawyers.com. I can be emailed at chris@providentlawyers.com. Our phone number is 480-388-3343. Thanks again.
Awesome. Thanks so much, Chris. We really appreciate it. We'll talk to you next time.
All right. See you, gentlemen.
Thanks, Chris.
All right. With that, everybody, that is our episode. Join us next week. We're talking foreclosure laws and anti-deficiency statutes. We'll see you then.